My recollection is he's first cousins to both Tony and Coppola. That's right. They were the two youths he was talking about back then. So we've got a few cases and a few rules. We'll get our rules out of the way first, then we'll go back and finish up our other case. But in part, my focus is for you guys to look a little more closely at the rules and their obligations. I know Professor Martin probably stressed the rules a little more than I did. But the fact is as we practice, it's even more important to look precisely at them and know what you're doing. Rule 11 is one, obviously I stressed, and I assume Professor Martin did as well. But Rule 11 is the attorney's obligation to really investigate the claims before advancing them. And if you advance whatever the pleading you're signing is, that you are representing to the court that in good faith that you've made an investigation to both the underlying facts and the law, and that the pleading is based on good faith and a good faith belief in that it's based on existing law or a good faith belief in reversal of existing law. And that it also isn't interposed for any improper purpose such as harassment or delay. And I can teach that, and we can talk about that, but unfortunately, too often, Rule 11 gets put to the side when you start to practice law, and you got the crush of everyday activities where people need things right away. But I've told you in the past, or some of you in the past, I think Rule 11 is a great rule, even if it didn't exist as a rule and a requirement, and as I see it, as an ethical restriction on what you should and shouldn't be doing, because what it says is slow down and make sure that this claim that you're going to invest a lot of time and money in, and whether it's your time in both your money or your client's money. In a lot of cases, you're going to invest not just your time, but your own cash in. Clients don't always have the money for their experts. Clients don't always have the money to pay right away for all the deposition costs, or there's many other items of cost that come along the way. So it's not always just your time and that you're investing in it, and whether it's an hourly or contingent basis. But sometimes you're going to invest your actual cash in these cases, and you need to know that this claim is sufficiently meritorious that you're likely to see a return on the investment of time and money. And so, to me, Rule 11 just says, take a harder look at it and then take a step back and try to make sure that the other side is not going to be able to say that this is improper for any reason, because they're always going to say that. That's the way life works, is that the defendant, as they see their job in defending the case, is to slow it down, to drag it out, and too often to attempt to assassinate the character of both the plaintiff and his or her lawyers. And so you want to know that your back is adequately covered, and also that you're not advancing claims where people could look at you and say you're just doing it to feed the family and the like. But not that feeding the family is bad, but you want to make sure you attach your name to cases that are sufficiently meritorious, both from the standpoint of plaintiff and defense, right? This is not just the pleading isn't the only the complaint is not the only pleading. Answers constitute a pleading as well, and so make sure that there's support for that as well. Although obviously every defendant's entitled to put the plaintiff through their paces to make them meet their burden of proof to show their case by a preponderance of the evidence. But at the same point, sometimes defendants tend to do things simply to drag it out, delay the matter, in hopes that the plaintiff will break before we're done. And obviously that would be equally improper to file pleadings for an improper purpose, whether you're representing the plaintiff or the defendant. The other rule that's listed for today is Rule 23, which are class actions under Section 4. Class actions is when a group too numerous for joinder have been injured as a result of common questions of law or fact. Because they're a group too numerous for joinder who have been injured in a similar fashion like that, they are allowed to plead their claims together, and in essence, some class representatives bring the claim on behalf of not just themselves, but all others similarly situated. Usually, it's for relatively small claims, but it doesn't always have to be, and sometimes we see them for bigger amounts. I know there's a Citizens Bank class action running around right now because of the way in which they did their overdraft notices. What they would do is they would post, if they had 10 checks to post, they would post the largest first, overdraft your account. Now you owe 25 for the first overdraft, and then 25 for each of the other 9. So instead of posting the smallest first so that you might not have overdrawn until the 10th check, they posted the big check first, and then you paid 10 times those overdraft fees. So that's one, but there's a bunch of others that you see from time to time. I describe the Rule 23 class actions now as having to satisfy what I call the 5 why test. And it's because all the words end in Y. Numerosity, group too numerous for joinder, commonality, who have been injured as a result of common questions of law effect, typicality, that the claim of the class representative is typical of the types of claims suffered by members of the class, adequately or adequacy, the adequacy of the class representative and their ability to represent the interest of the class. When we look at adequately or adequacy, it is not just that the person who's named class representative has the wherewithal to be able to potentially advance the claims, but their counsel as well, which could be you. And so the court will assess in certifying it as a class action whether the class representative can adequately represents the claim of the class, and whether that representative themselves can, adequately represent the interests of the class. The last why that we've added in recent years, and the Supreme Court was getting to this, but I think specifically after the Walmart case on the sexual, the sex discrimination case from the standpoint of wages, I think is the last why now is manageability. And what that really means is in this assessment is the court goes through and makes an assessment whether the case is really manageable as a class, whether the claims are such that it is a superior way to handle it as a class as opposed to separately. And what they did in the Walmart case at the end of the day is they said, there is no smoking gun, in essence a policy by the company that says females will all get paid less than their male counterparts even though they do the same job. In discrimination cases, you're almost never going to see such a document, but that's what the Supreme Court was suggesting. And absent sort of a blanket policy by the company that you can point to, each female's claim stands and falls on her own individual situation, and therefore, the court at the end of the day said, let them sue individually. Now, the fact is many people won't because they're afraid of annoying their employer and losing their job. Some of the claims will be relatively modest, and for Walmart it's a lot easier to beat back people one at a time than to have all of these people band together. At the end of the day, Walmart won the argument with respect to the courts saying that it shouldn't be certified as a class because it's not a superior way of managing this controversy. It'd be better to let each female plaintiff at Walmart file a separate suit. And obviously, that's going to save Walmart ginormous amounts of money in the process, and that was obviously their intent. When a class action is filed, it's filed on behalf of others, but usually there's 1, 2, or a handful of class representatives. And then at some point, relatively early on, the court has to decide whether the class can be certified. And when the class is certified, that's usually when you see those notices by postcard or in Parade magazine. I see a lot of them where they're saying, hey, you may have a claim that the following happened to you. The likelihood is that the class has been certified at that point, and the court is looking to see what the size of the class is. There are, as a general matter, because of this manageability factor as well. Contract claims, obviously, as a general matter, are relatively easier to find to be manageable. You know, if you all paid $50 for a book, the damages are pretty typical. We could say that that's probably a superior way to handle it. When they are tort cases, like the breast implant cases, or cases for personal injuries, like the smoking cases and the like, it's a little harder and more fact-specific of an inquiry, and oftentimes it's harder to get tort-type injuries and claims certified as a class than your relatively more straightforward contract claims and the like. But both have been certified at various times. But the trend over the last few years is to make it harder for plaintiffs to be able to pursue class actions and certainly keep them in state court, because the rules on getting them to federal court have been eased as well. So there's a whole bunch of things in play with respect to it. But the last case that we had to do from Section 3 is Zapata versus Dairy Mart. Because we looked at Anthony's Pier 4, and Anthony was arguing there's no covenant of good faith and fair dealing in business contracts, and the court said there is. And then we've got our Zapata case where, I'll be honest, I feel bad for Zapata, but that's just tough luck. Is it? I mean, the agreement said we could terminate at any time. They decided to terminate. They had given him options. He made choices. Out he goes. Pat, yeah? You shrug your shoulders, yeah?
Yeah, I mean...
So you'd have no problem kicking this guy out to the curb as Dairy Mart's lawyer?
Am I the resident bad guy for the semester?
Well, no, I think, as I see it, I think you're all resident bad guys from what I can understand so far.
No,
No.
That's why we said...
Even my friend Sunshine over here, I think, is going to kick him out.
That's why we said on the other side of the coin, if we're representing the guys, Rudgewitz,
Yep.
you know, you got to read that whole thing. Let them know what could happen if X or if Y. And Zapata should have known that before he signed up with D-Mon. Same thing.
Well, they even told him, hey, go take it to a lawyer, right?
Yeah.
So what's the point? So that's the point? We can lead a horse to water if they don't want to go. At the end of the day, I got to execute the hand on behalf of my client. Even Sandy says yes.
Yes.
So you say, out you go.
Out you go.
The provision says, what, 90 days, so even less. I think they say 90?
Yes.
Yeah.
They offered to buy his stuff back. He said, no thanks. And so now you're going to go in, put the foreclosure sign up, and send him on his way.
Well, they're just going to get somebody else to run the store.
Huh?
They're just going to get somebody else to run the store.
They are.
Yeah.
But he's out.
He's out.
And you're throwing him out.
So let me try to argue the other way. First, I'll say I agree with finding, because in this case, you know, like in the business world, it's usually employee at will, so that they don't have to have a reason. In this case, it's not really a real franchise in that it wasn't a major investment for this guy, and they were going to buy him out, and that was part of the contract to buy out his last inventory. So he really didn't have a huge investment. So here was almost like an employment at will scenario. So that's the argument for kicking him out. His best argument, in my opinion, against them is, wait a minute, no, there was an investment. I did have to buy the first amount, and yes, you buy me out at the end, but you leave me 20% less, and so there's some economic investment, whereas a standard employee doesn't make an investment. He doesn't have to just have a penny to get the job. I had to spend money to get this job. So he can say this is a more typical franchise than an employment arrangement, and thus it's what do you call it, unconscionable. So that's his best argument, but in the end of the day, I don't think it's strong enough, because a typical franchise is a massive investment. That's a stronger argument. Here he doesn't have that. So
I have to say, though it is lawful, I do not agree with it, and I do think that this franchise situation is like a gamble, and I hate to say it, but it's almost like they're prying on the little people. So yeah, legally they may be right in doing so, but I do think that if I was a franchise in a perfect world, I would want to help people come back up, not all of these people are giving Subway a bad name, they're giving Dairy Mart a bad name, and that's not good for your reputation. So I think that in essence, yeah, they win, but do they really? Don't they lose once the word of mouth gets around, and how now franchises is a negative thing? People are not going to want to do it, so they're ultimately hurting themselves.
But it would be relatively odd to say that for some reason I can't terminate the contract in accordance with its own terms.
Right.
No, I mean, because that is what we're talking about, right? It says that we can terminate upon X, and that's all they've done.
Unless they
But the result seems harsh, but it is what we said all along that we had the ability to do.
unless they could show that the terms were unconscionable.
Right, but unconscionable is going to be a pretty rough road. You said the 80%, but I just double checked the 80. It's 80 of retail value.
Right.
That's not bad. That's probably well over and above what he paid.
Probably matches wholesale, yeah.
Oh, I'll bet it's better than wholesale. 80% of retail? He's doing pretty good, don't you think, Pat? So,
Yeah, so it's no investment, so it's not.
and not just stuff he purchased from Dairyman, all of his retail at 80%, all of his stuff in the store at 80% if we terminate him. But he's still out of work. This happened to my little cleaner down the street. They didn't even have a repurchase. The landlord just jacked up his rent, and out he goes. I said, what? I said, how come? They double my rent. I can't do it. Little guy would be there at like 6:30 in the morning and be there at night when I'm going home, and now he's out. There's something wrong about that. Isn't that, Sandy? But Sandy, you're going to be representing the man here? It's kicking him out in the street? Because that's what the contract says?
The contract says yes.
Yes. Go ahead.
I don't think, I mean, we're picturing Zapata as being this small, he was an experienced businessman. He knew what he was doing when he signed the clause, when he signed the contract, and he understood the clause, you know. So he got into the contract, and we would be setting a bad precedent, I think, if we said, oh, don't follow whatever the contract says, and let the little guy, you know, give him a break this time.
So you guys would enforce the terms of the contract. If your Dairy Mart's counsel was saying, no, it's the deal is the deal. I'm sorry, but the deal is the deal. Just like that landlord down the street with my poor cleaner. Deal's the deal. You rent. Time's up. I can jack up your rent. And you're a commercial tenant, so you don't have a lot of protection. Pay it or go. He's telling me. He only gave me 2 weeks. It doesn't seem right, but I'm not a landlord guy.
But isn't that why they have the clause? I mean, like, that would kind of break a barrier to the clause of termination, like, at will. Like, that's why the clause wasn't in the contract. So-
But doesn't sometimes, though, okay, and I wonder whether this is one of them. Okay, so you're right. We're lawyers. We understand, and the law is the law. But geez, you're leaving a little bit of carnage in your wake here, aren't you? But that's what we sign up for. That's it. We don't care. We don't care what's right. It's the law, and my job is to enforce it. And if he and his kids go hungry next week, I represent Dairy Mart. I don't represent Zapata. Is that? Can you separate out, by the way, because that's sort of that segues into the next one. Are you all comfortable that you're going to be able to readily sort this out in your personal lives, that stuff like this won't bother you? Because I'll be honest with you, if I had to throw them out in the street, it would bother me. I'd probably be able to do it like you, but
Might bother you for a minute,
but it might bother you for a minute. Oh, and you wonder why you might be seen as the bad guy, Patrick. Go ahead.
But this, just as the gentleman said earlier, we're talking about experienced businessmen. We're not talking about a novice. We're talking about somebody who's conducted business several times over.
And he was told to take it to a lawyer.
He was told to take it to a lawyer. And I don't know whether or not, I wasn't there, but I don't know whether or not he had too much of a pride in saying, I can do this on my own. And, what we're seeing here from the last case to this case is just a misstep. Just that you didn't take their advice. And this is what happens.
and there's no showing of any unfair, deceptive,
faith.
or
No bad
bad faith.
No, I disagree. I respectfully disagree with both counsel. I have to say yes, but even they,
Wait, yes,
they are-
what? You think
Yes, they are businessmen, but even businessmen make mistakes. But I do think that the contracts that these franchises have are one-sided. They're one-sided, and they're not good for the little person.
Well, what do you guys think about, I mean, do you disagree, the franchise agreement, let's be honest, are one-sided, right?
Right.
Absolutely, but.
But you know that going in.
Knowing that going in, even with that, in this case, he was told
Right.
to have an expert or have someone, i.e. the attorney, look it over. And he chose to go forward.
Or at least read it yourself.
Right.
You probably didn't even read it. Who knows?
But he also offered a compromise with the store, and they said no. They didn't want what he was offering.
Well-
They offered him something, and he said no. Then he said, can I do
Right.
this? And they said no. And my thing is, if we're thinking about business, without the contract set aside, your name is on the front of that store. You want to do well, at least you should want to do well for your franchisees, I guess you would say, so that would promote your business. And if you're stepping on the little people, eventually, they're not going to want you. And the reason I say that is, I lived in Hillsborough, and I wanted so bad for a Walmart to open there. But everybody in that town did not want a Walmart to open. They promoted small business. And I wondered why. Well, now I know it's because the big stores come in, and then the little people don't have the money locally. It's gone to the main headquarters, and we lose out that income. So I think that if you're gonna start doing franchises and you wanna promote your business, it makes perfect business sense to wanna say, let me help out this little man that wants a franchise, instead of stepping on him along the way and leaving carnage, like Professor Point said.
Okay.
Go ahead.
Okay, so I agree that any good business wants to keep their image in the marketplace solid, and that's a valid and huge argument. If I was counsel for Dairy Mart, I would advise their business policies to say, make sure you're really careful on who you hire and who you put in there so you don't have a high turnover. Okay. However, I think in this case, he didn't want to stay open the amount of hours too. Is that this case or the one before that? Okay, so they gave this guy plenty of opportunities. It wasn't just that he's a businessman. It wasn't just that he didn't read or didn't give it to the lawyer. He also was given plenty of opportunity, in my opinion, to open the hours that he was supposed to. He was also offered a different location, if I remember correctly, as well. So in my opinion, Dairy Mart was working with this guy and trying to help him. And in the end, it's like the other thing about franchisees is they have to have, like the Burger King case. Is that this class or a different class? But anyways,
No, we did Burger King.
the Burger King case, franchisees have to come down hard on these rules. They have to have, uniformity with Dairy Mart here, Dairy Mart here, Dairy Mart down the street. So they have to come down hard. So there's the other argument, and then your Walmart argument. Okay, there's people that will argue that you're helping the little person. In business, there's no such thing as little person or big person. You're right. You have to have good consumer image. Okay, it's not about socialism. It's like, what a lot of people argue Walmart helps the little person buy cheap goods. So there's two arguments to that.
And I have to say, just to reiterate to you, they allowed another store to open up and cause him competition. And they offered him some stuff, but what they offered, they were not, you said that they offered plenty. They didn't offer plenty. They only offered some things, and they weren't seeing eye to eye. And I think that my Walmart argument was sound. More time to prepare, I would have had illustrations.
And I think it was too.
So no one doesn't appear really troubled.
I do.
Troubled to the point where if you were working for Dairy Mart, you'd say, no, you shouldn't do this? Or you'd say, you shouldn't do this, but okay, I will if that's what it takes. If I go on to work here, you're going to do it.
Troubled with the disclosure, I think that the disclosure...
No, trouble with kicking them out.
Yeah,
Well, when you say you're trouble with the disclosure, by the way, the language is here that he understood every term and every provision with respect to the termination and the disclosure.
But you know that those disclosures are overestimated. They really make it look beautiful.
But it says in a couple places he understood every word in the provision.
So, okay, so then to change it, I would say that...
But it does say, though, in fairness to you, it says, and just see this now, he had interpreted to mean that Dairy Mart could terminate the agreement only for cause, but it's not what it says. So-
Well, thank you for saying that, but, so then I wouldn't represent them and I would educate the people if they want to be in a.
Okay, but what if they say, no, we want them out? For policy, we want them out. We want to tell, we're not going to deal with franchisees like this again. Take the deal or leave it, and we want them out now. And so, and the same thing could be with the firm you're working or whoever it is you're working for, right? We don't always get the side we want in our cases. So, I mean, because this isn't that bad, is it? Well, listen, you had an agreement. We told you to get a lawyer. The clause is pretty clear. Time's up. You made a bunch of bad personal decisions here too, right? Sign the new franchise agreement. No. We'll buy 80% of your property back. No. I mean, frankly, you don't have a lot of leverage here. You're playing a bad hand. At the end of the day, the hand doesn't play out well for you, right? That's the nature of life if you overplay your hand. But with all that said,
he also knows that he doesn't have a huge financial investment, so he's got.
well, how do you know that, by the way?
Well, he did that first
Because I don't see that here.
the first inventory, I guess, and then they buy out his inventory, like you said. So that's.
But he did do something. I mean, he undertook a franchise relationship, which I would imagine, and we don't see that, and I'm surprised the case doesn't tell us, he must have made some cash investment in that.
No, that's what I'm thinking. I'm thinking.
Well, what you're thinking, but I know what you're thinking, but what I'm asking is I don't see those facts anywhere here. Do you?
Yes, but it would be key to the case that they would put those facts in here if it was the case, because.
Which was the case? If there was zero cash investment, or if the cash investment was X?
If there was a cash investment, it would have to be a significant factor to put in the facts.
It wouldn't be important to the facts of the
It would be,
disposition
my
they want
point.
to say there was zero cash investment by him? Because you're reading it, since it doesn't say a number, the number must be zero. Well, it helps your argument. I don't know
But
whether.
that's an assumption.
Yeah, it's a big assumption.
But I would not make the assumption there was either.
There is, no, that's not an assumption. I
didn't see it.
Well, you know what, let me
And I looked
read it
for it.
again.
I think the
I think
case
he
is
did have
somewhat,
to-
is silent with respect to it, and I think I would like to know that.
And that was very, I looked for it, believe me, because that would make sense to me. Because that's why I was doing that whole at-will argument. This is an at-will arrangement. This wasn't your, this isn't your standard.
It says right here, as an investment, the Zapatas had only to purchase the inventory of
Yep.
goods to be sold out.
So it's still an investment though?
No, because he bought
But
it
there's no
out.
additional cash. He bought,
Because
because
they buy it out at the end.
all he had to do was buy the
The
goods.
The initial inventory, knowing that it would be bought out in the end if it didn't work. And once I saw that, I said, this is not your standard franchise scenario. This guy can walk in and walk out real easy. So he knows.
But Gary, doesn't matter to you that he probably was putting in 70 hours a week at the store?
If he was
You gotta know
incapable
you're
of
gonna do
hiring.
that.
Huh?
You gotta know you're doing that if you open a convenience store.
Right.
Because you can't afford to.
Okay, so he did know, yeah, I don't see, he did know that, but so that sweat equity doesn't count as equity?
Hey, they gave him a job, you know, and they said, here, this is what you got to do.
Gave him a job, I was making money for Dairy Mart and probably for a reasonable period of time. And as you point out, well, as you inferred, and I'm not so sure it's not
Alleged.
correct, that this may be some way to subvert the wage and benefit and employee-employer laws. We'll make you a franchisee and we don't have to pay you minimum wage.
Yeah, you know, and work 70 hours a week or whatever, I'm sure, but or be good enough to hire somebody to do it for you. But no, my argument actually is, even if he's not a savvy business person, he's got to have enough common sense to say, hey, listen, there's no massive investment on my part, so I don't have a lot of skin in this game. So they obviously know I don't have a lot of skin, so I could walk away in 90 days too. You see, so both sides are like, both sides are saying this is not your standard franchise where both parties are invested heavily. This is a 90-day arrangement where either party can walk away, like a lease in an apartment. It's not like you had to buy equipment. It's not like, you know, that's what this one was different.
So out he goes, and you're going to be the one that calls the moving truck and helps him out here. Because that's your job. You're working for Dairy Mart.
If Mr. Zapata came to my office, I would have I would try to come up with an argument, I would argue the constitutionality of the agreement. And
But how? On what basis?
on
Because,
basis, because they have 90 days, either can opt out.
Right.
correct? We have.
Oh, right.
We have a big pocket, what do you call it, deep pocket, and we have one who's just hoping to make a living.
But
I
you're
would
both
argue
business
the
people at this
I would
point.
argue that the 90 day is not reasonable.
Unconscionable. I think that's what they did.
well, but they tried that, right? I mean, I'm with you. They tried it, and the court at the end of the day says, well, it's really nothing commercially unreasonable about what's going on here. And the fact is that's what the term says. He appears to understood it, had an opportunity for review. Out he goes. I mean, as things go that lawyers are required to do, this isn't that bad. Because you made it yourself Zapata's attorney. I was asking you to be Dairymont's attorney. And I'd rather represent him too, even though we're going to lose. Because I don't like kicking people to the street.
He's not gonna go to the street though.
Huh?
He's a businessman, he's not gonna go to the street.
How do you know that? My poor cleanup guy. You know, he was a businessman 2 weeks ago, and now he's out.
He'll bounce back.
Your cleaner guy.
I hope he does. I should have got his phone number because I'm thinking this guy is one hardworking guy, and someone ought to put someone in touch with some money with this guy because he's going to make someone money because he worked hard and he deserved a better fate than the greedy landlord doubling his rent.
Your guy has a better argument.
That's what happened with Zapatas. The same thing would happen to them. They said
You're right.
They were gonna increase the rent and
Yeah, but the
other
difference between
costs.
your client and this client is that Dairymont tried to work with Zapata. Nobody tried to work with
It's fair enough, and that's what he said. He said, "You can't make money doubling the rent like this."
I had a question on whether an argument could be made that there wasn't sufficient, adequate consideration in the contract because,
I like that.
Well, we both made mutual promises, though, right? I promised that you can run with my Dairy-Mart name and be the franchisee. You promised that you'll operate the store reasonably and sell my goods under the Dairy-Mart name.
and it's as
So it's a
simple as that.
bargain.
I was just thinking
Yeah.
in terms of the investment versus the buyout. Where-
Well, I wonder what the cost.
They offset each other?
Yeah, I was wondering that myself when we were thinking about, what was the buy-in. I mean, because if he had to buy it at retail, then he only sells it at retail, which it can't be because then he's making no money.
Right.
So what was when it said he had to buy the inventory at what price? Because is he still making money at 80% of retail, which I think he must have been, because otherwise if he buys it at retail, he can't make money.
Right.
No.
You don't know what the markup is.
Right.
On that stuff, I'm sure it's real high.
Oh yeah. Oh yeah.
I don't know if that argument was raised, because I read this a couple days ago, but couldn't he have raised the argument that the loss of income, future income? I mean,
Yeah, but the
People
deal
time here.
the deal is if I give you 90 days, we're done. Right? That's what he's saying. 90 days. If I give you 90 days, we're done. And he's trying to argue that, well, that I know it's a provision in the contract, but that could be unfair under the circumstances and unlawful. And the court goes through and says, well, there's nothing commercially unreasonable. There's nothing unconscionable about what they're doing. If they said a day, maybe we could say, well, that's unconscionable. But 90 days, that gives him some time to get his affairs in order and move on. Let's look at Section 4, which is Rule 11. And I still give you the Unioil versus E.F. Hutton case, even though Rule 11 has changed a little bit over time, because I think it's important for you to recognize that's, and by the way, there are other bigger numbers now. I saw one, but I think it's more related to a discovery abuse / Rule 11, that the fine was $5 million. But this one, I still think $300,000 is an awful lot of money.
So that ruins you, though, right? Your malpractice insurance or whatever.
Well, let's talk a couple things. First of all, malpractice doesn't cover Rule 11. Okay, Rule 11 is the court's sanction to you, sometimes to your attorney. It's not going to be covered by your malpractice. This is your personal assets. Yeah, these are your personal assets that they're looking for. So that's the first thing. You may well be a malpractice claim coming, and then that's going to go against your malpractice policy. And from that standpoint, the day you leave law school, your malpractice premium will be as low as it's ever going to be the rest of your life. And the reason for that is obviously you haven't committed malpractice on day one. By day two, you might have. And now your premium goes up because it's a claims-made basis, and the longer you practice law, the more claims you can have. So your cost of malpractice goes up over time. It's not like a driver's, your 17-year-old driver costs an outrageous amount. It works the other way. But the Rule 11 sanction is really just the start of it, because then the judge is likely to report you to the Board of Bar Overseers, so then there's going to be some type of disciplinary investigation potentially as well. This Joe Alioto was the former mayor of San Francisco. The Fisherman's Wharf is where their family restaurant is. You've been down there. He is one of the most well-known antitrust lawyers at the time. It was in the country. In fact, he represented the Raiders when they sued the NFL. He got fined nearly $300,000. So what would they do to a schmuck like you? No, really, right? Because he's going to get the benefit of the doubt, right? You and I are not. And that's why I still think it's important for you to look at this case and recognize that even a well-respected, well-regarded, highly successful lawyer, when the court finds there's been a violation, comes in and hits him incredibly hard. The good news is Joe Alioto probably had an extra $300,000 or $400,000 hanging around. I don't know about you, but this for most people is pretty much bankrupt money. So what? 5 years from now, one of your classmates remembers one of the extremely intelligent things you said here around this table and says, I'm going to call X because I remember that remedies class. They were just brilliant, and they can help me with my case. And they say, listen, I got a great case. Go in the middle of discovery, I need help. And I think both of us can make beachfront homes with this type of case. TD, you in? Huh? Well, I'm wondering what you want. Are we in? This is big money. Big money.
Tell me more.
Well, I'll tell you about the case. We're just getting started with discovery. Hail the door, or pick some big blood-sucking defense lawyer law firm downtown who's going to go with their scorched earth strategy. And if we're successful, we're looking at north of $10 million.
What if we're unsuccessful?
We got it on a contingent, so divisible by 3. We split it. That's that's $1.5 million each.
As long as I don't have to sign the complaint, you sign it.
Oh, so you're not going to sign the complaint? I mean, you'll sign the pleadings or no?
Oh man, no, I'll just help you with the case.
Well, but I want as a strength in numbers. I think if we both sign, it looks like we're more impressive, and they're just not, against little old me here.
I want to know what would happen if we lost. I mean, I understand.
Well, if we lose, we lose.
Okay.
Right? We get no money because it's a contingent basis. But if we win, we're successful, we win everything. I wonder what you need to know or what you need to do.
What's your strategy?
Well, my strategy is to get enough discovery that we can win. We'll say it's one of these. It's an antitrust case, also 93A, you just saw that, and it's a breach of contract. What they did at the end of the day is they made believe they wanted our product, and then at the end of the day, they stole our product and manufactured it under another name.
Are you adding plaintiffs to the case without them being present?
No, your plaintiff is a relatively small business. That's who they were. It's they invented it. They were manufacturing it. One of my graduates one time, he had a case. It was a street hockey puck, and another company stole the street hockey puck and made a lot of money with the street hockey puck, and ultimately had to sue. Invention disputes are good. Huh?
Have you asked questions like, have you interviewed the plaintiff?
Yep.
And
solid.
Has he agreed for us to represent him?
Yep. I've got a fee letter, and he says I can bring on some help, and you're the help.
Okay. you have his story covered.
What's that mean?
You know the facts of the
Verified.
case.
Oh, I verified the facts. So you good with that? You good with my assurances?
Well, so
No,
far,
do
yes.
it yourself.
You got to do it yourself.
Yeah.
Yeah.
Yes.
So you can't. So if Kelly tells you it's a good case, I look up the law. It's good. Facts are good. Solid. Now what?
I would conduct a reasonable investigation.
Yeah.
into
So
the
okay,
facts.
okay. Listen, I know that's what you have to tell me. I want to know. I want to know what that means to you.
I think it would.
Listen,
That means-
Because I get these calls, okay? Mike, the law is really in our favor. The stack of law is like this. Do I got to read? No, just for those online. That's about 2 feet of real legal research. Do I got to read 2 feet of legal research? I've got 5 bankers' box of documents at
Being
this
honest,
point.
you ain't gonna read it.
No, you're not gonna.
Whoa! No, okay. So just feed your family. Don't speak to me. Just speak to me, okay? Because if I'm putting my name on it, I just want to know what I'm supposed to do. Do I have? Go ahead.
So we just decided that if you get sanctioned by Rule 11, you're ruined, pretty much.
It could be. You see how much money it could be.
300,000 to 5 million.
Could be.
Anywhere in there, I'm ruined. So. So yes.
So guess what? Read 2 feet of documents
I'm gonna read 2 feet of documents and then I'll
of the
sign
law.
it.
I can't say give me your top 5 cases for, give me your top 5 cases against. I got to read all the crap that
No.
you've already discarded.
But see, in real life, it doesn't work like that. You base it on Kelly's credibility because you know Kelly, so you know that she's not gonna hopefully throw you on the bus.
It's such a Ash, tell her that again, Ash, because I'm not so Sunshine read her cases tonight.
No, but I'm just.
But that's what he did, Sunshine.
I know, but that's.
How did it work out for him?
It was bad, but
So then why would you say, let's do that?
in real life, the firm that I'm helping out at, that's what they do. They tell you this is this.
Okay,
this,
but
that.
maybe
Nobody
that
says
firm
they
doesn't
really
do it
know
right.
it. Yes, maybe they're not, but they've been in business for 37 years. But what this guy did in this uni oil was he added. That's why I asked you: are you adding plaintiffs without getting their approval? Because
No. This plaintiff had approval. Okay, so the lawyer had the client, and the client said, we've got a suit. It wasn't until his knees buckled at the deposition that we found out he didn't.
He didn't speak to the attorney directly, though. It was through some other guy.
You just said it was okay. You just said that's okay. That
No.
when Kelly says, Mike, good case, good client, good facts, good law, I've got the documents, I've got the law, I say, Kelly, sign my name to that complaint.
Because
that's what you just said is okay to do.
if Kelly calls some of her peers from MSL and
Right.
says, I got a good case. Knowing Kelly the way I know her, she wouldn't throw me under the bus the way I threw her under the bus last week.
Yeah.
So, you did that.
This is sunshine.
But I
How'd
would
that
want her
work
not
out?
to
But
say-
Not too well.
Ash wants you to respond to his question.
What's your
Isn't that precisely what happened in Unoil? And he got killed for relying on another attorney who said everything's great.
Yes, that is exactly what happened.
Okay, but then so how can you rely on one of your colleagues here?
I don't know him personally. I do know Kelly. Your question
I
was.
know Kelly,
Your
too, but
question
Rule
was.
11 is gonna be killing me. You bet I'll be reading every piece of paper she
See,
hands
but
me.
they don't
That's
do
the
that.
point.
They
The
don't.
point
They don't.
is
In real
only
life,
agree
you're in a
later
hurry. They
on.
don't.
Wait, only one of that kind of you all three. What?
Talk show.
That's what happened. We have 3 women.
I haven't even started in Spanish yet. I'll go back. Forget it.
Okay, wait a minute.
Wait, from my understanding, the plaintiff only agreed later on. He didn't agree from the beginning. It says-
I actually thought, and listen, this is part of the problem with these class actions as well here. Oftentimes, what happens is the plaintiff's class action bar. They know of the case. They know that there's the federal government has stepped in. They know there's a case. Then they go running around to find a plaintiff, and then they go running off to court right away because they want to be the lead plaintiff's lawyer, and so they want to direct the class because there's big money in these cases. So what they did is they found the stockholder. He agreed to be the named plaintiff, but they didn't shake out the facts well enough, and they got Alioto because the reason, listen, if it's one of us, if I can get Joe Alioto to sign my antitrust complaint, the defendant's going to take it a lot more serious than when they see Mike Coyne representing the shareholders. They say, oh, geez, they got Joe Alioto. He's the big deal here with antitrust. So he signs his name because he wants to get a lot of money too. No one did their due diligence. And I'm wondering, listen, sometimes I get calls a lot from graduates where their cases are in trouble, or even professors. They say, Mike, this case looks like it's going to be discovery and trial, and that's not what I do. Would you sign in for this? And I'm wondering, even with your my fellow professors, your professors, I can just take their word for it?
You're going to be opening up yourself to liability.
Ash says no. What do you say? No.
No, absolutely.
I need to investigate
Yes.
myself,
Yes.
make my own analysis.
Yes. According
And
to
I
the case,
say in a
Bill.
real world, not everybody does that.
Oh, okay, but I need to know the real world you're going to practice in, that you recognize that that's dangerous. And not just dangerous, we're past dangerous when we're looking at $300,000, right? And I understand what Sunshine's saying, but that's the other part of it too, is sometimes over time, you develop sloppy and bad habits. I'm not trying to badmouth anyone here, but recognize the reason I pull the case out is that you get these calls, okay? And so then the question is, in or out? And then, okay, if I'm in, what is it, how extensive does it need to be? Do I have because you're telling me now, I thought you said, I can't even rely on Professor Malaguti.
No.
No, right? No, that's what you're saying, right?
No.
Who clearly is really one of the best lawyers here. Probably the second best, you know what I mean. No, he's very, very good. But I can't even trust him?
No. Well, like I said, you open yourself up. Look, for $300,000, you're going to open yourself up for that.
Absolutely not. So wait a minute though. You guys know you've done some legal research now. I got this stack. Not the whole stack though, right? Can I say, give me your best 5 and your worst 5? Because right, when you guys do research, you find some that are dead on, or you hope. But a lot of them are in the middle, and you say, not so helpful, not so helpful. Like I usually rank them with stars now. So I got a 1 star. I don't have to look at the 1 stars, but I should be looking at the 4s and 5s, shouldn't I? Because the 1 star really, in essence, is virtually discarded research. Do I have to look at Kelly's sloppy research? I got to look at all the crap that she thinks isn't relevant or marginally relevant? Do I have to look at some of these cases, especially a case like this? You might have 100,000 documents. Do I have to look at 100,000? Or how about I say, give me your top 100 documents?
Yeah, but what if the other documents are relevant? Even though she says they're not, there might be something that is. And you don't.
Okay, but realistically now, you're telling me I have got to... That's a lot of work before I ever even decide. I mean, that's a lot of work for free.
Yeah.
Right?
Yeah.
But realistically, you're not going to do all that for free, are you? And that's what I'm wondering is, how do I make sure I've done enough and make sure I'm comfortable enough? Because I've told you, I think this rule is a good rule anyway. By the way, did you guys, did you talk to the plaintiff?
Okay, that's my next point. Elliot never spoke with
Hey,
his prior to
that's my
filing the
point.
complaint. And then it says here, nor did he inquire whether the other attorney investigated whether he's a good fit as a plaintiff. So what I would do in that situation, I would talk to the plaintiff, and if I had like a paralegal assistant, I would say, give me all the documents that you have. We're gonna just
Talk in person or on phone?
I would talk in person.
I'm from California, I can't get there.
Skype.
Skype.
Well, let's
I would
So would you? Is Skype good enough, or you just
Yeah.
need to be in person?
Skype.
Okay, so but I need to see the person.
I would need to see the person.
Well, do you think you need to see the person in order to satisfy Rule 11? Not just what... Well, we're talking about... See, my work, we're talking about discovery and trial. And I'd like to tell you that the looks don't matter, but they do if we're going to trial, don't they? I mean, I need to know... If I'm assessing that, I need to know how you're going to present. Right? Don't I? I need to know whether you can look at me and you look sincere. If you're looking away every time I ask you a hard question, that's not a good sign, right? So I do need to physically see you. Phone call, are you guys prepared to say phone call's not going to satisfy Rule 11? Sunshine, what are you saying now? Because I bet there's not even phone calls, some of those cases.
Yeah, I'm on the fence. And the reason I say that, there's 5 attorneys that work there. So if one says, oh, can you sign on? They don't necessarily verify a packet.
Wait, 5 attorneys within the same firm?
Yes.
I think that is slightly different as a general matter. If I can't trust my partner, by the way, I don't think you can to satisfy Rule 11. But if I have a partner that isn't trustworthy, then he shouldn't have been my partner. So
That's why I say that.
it's a risk, but
Yeah.
it's less of a risk because
They're all-
I made him my partner. But listen, I'll tell you, he wasn't my partner. But I worked with the lawyer in Boston, who I wouldn't trust to save my life. Because I've used him in illustrations and other times. He would just promise everything, and then when the whole case exploded in massive flames, he'd come and say, "Mike, I don't understand it." And I'd say, "What don't you understand? You've been pouring gasoline on this for 6 months since you took the case. They have ridiculously unreal expectations because of what you've done. And now the shit has hit the fan. What's not to understand?" So you will have people within your workspace that you don't trust as well as others. And if that's the case, I mean, listen, I trust Ash completely. But if I don't do my Rule 11 investigation, I sign on, and that trust, as it turns out, was misplaced, I'm getting sanctioned. And no matter who it is, you're getting sanctioned. So now you're telling me I need to see the person face to face.
Well, if it's a big case like this, yes. If it's just a...
So a little case where the sanctions would be less, not as important? No, but this is where we set the fudge line.
But I think if I'm going to trial, I want to see.
Well, don't we have to start with the expectation? And I think you should. But shouldn't you start with the expectation that everyone's going to trial? Every one of them is going to trial, unless something great happens. I got to think about it from that standpoint. So we're going to meet. But it doesn't need to be face to face. We can use technology. We can Skype. You all comfortable with that?
For now, I mean, as trial gets closer.
Oh, sure. At some point, there's got to be closer.
Yes.
I didn't quite hear the answer to all the research, or just some of it, and I didn't quite hear I didn't hear the final answer, I think, to all of the documents or top 100 either way. Because honest to God, seriously, I've been in cases where when we're talking all the documents, you're talking hundreds of thousands of pages. Hundreds of thousands of pages.
I think I can go with the top 100, and through that I can see the pattern. And if I need to go deeper than that because I'm just not understanding where going with it, then I can see going further.
Yeah, but then you may have a very important document all the way at the bottom.
I think if you're not ready to take on that workload, don't sign your name to that complaint.
Okay, but listen, when you say that, and I want to be practical about it. Okay, when you say that, you might be talking in a case, like this, but just in some of these bigger cases, you might be talking 100 hours worth of work, 2 weeks worth of work for free, because if you're not going to take it, then you've just lost 100 hours billable. That's what, 5% of your yearly output. That's a big hit. And that's all. I'm just wondering where the line is. How far do you go till you get comfortable? Because you will call each other at some point. I get a lot of calls from graduates. I've got this. I think I need some more help. This is what's going on. And the question is, well, at what point do you say okay? What do you say no to? And how much do I have to look at before I make that decision? And that's what you've got to decide, because, well, hey, listen, I know you do 93A work. I saw your case in Lawyers Weekly, very successful, nice hit. Can you work on this case with me? And so,
it's one of those classic depends, because
it is. I agree.
In the real world, like she's saying, it depends who you're talking to. Also, as an inexperienced lawyer, you're going to do more time and also you're going to look at these Rule 11 cases that set the precedent, so you know how much you have to do and how far you have to go. So does it have to be in person or not in person? How many cases do I need to look at what this person has? It's going to depend on lots of variables. How reputable, how much do you trust this person? How solid does it look like the evidence is? And you're going to look, and if you're inexperienced, you're going to go back and before you sign anything and start doing some research on Rule 11 signing. How far do these judges want you to go? Because the judges are going to decide if you didn't do enough due diligence. He's the one's going to say, you didn't do enough due diligence. You got to convince him you did.
But you do know from reading this case to rest on someone else's representations
Right.
is clearly
No matter what,
insufficient.
no matter how much you trust
No
them.
matter how much you trust them,
Yeah.
is clearly insufficient if you don't do your own investigation, no matter who that person
In other
is.
words, case precedent, judge is gonna look at you and say, that wasn't enough.
So if I say, no, it was Professor Malaguti, I can say, that's tough luck for you.
Yeah.
And this is what I think you want to think about. And then the question is how much more. And listen, I'd love you to be able to say, I need to see everything. And you should. Ideally, it's probably a pretty good way to start. But when everything might be a lot, then at some point you got to decide, well, and if it's a close call, and I think the point is right, then I got to keep looking. But if I'm overwhelmed relatively early on with the strength of it, but that may not be the case, because if you're coming in, there may be trouble, and they're not coming into a gravy train. Oftentimes you're coming in because there are problems, so I need to know where we're at and what the problems are, because you don't want to sign in to sanctions, obviously. And a lot of bigger cases, and even smaller cases, that is not an unusual threat. That you better watch what you're doing here, you're way out of bounds, and I get those calls too from people. This is what I'm doing, and this is what they're saying. They're saying it violates Rule 11. Well, what do you got? Tell me about the case. And you go through it, and what it often is, it's a threat to an inexperienced lawyer, to an attempt to intimidate them. And it happens a lot, and so that's the other reason why Rule 11 is important. You want to do this from the outset, because you don't want to have your knees buckled when they do throw that card out, and it's oftentimes going to be thrown out there. You want to be able to respond and sleep comfortably that you've done everything you could, and you are more than comfortable with the strength of your case, both factually and legally, or you wouldn't have been here in the first place. Because it's those cases then that you didn't dot your I's and cross your T's, you didn't do everything you should, and now all hell is breaking loose. Those are the ones you don't end up sleeping through. I mean, you have an easier time kicking Zapata out in the street than sleeping where you think they're coming after you now because you've messed up on more than one occasion here, and they're looking at your house potentially being in the pile here. Those are the ones, obviously, that strike the most. Before we get to First Technology Safety Systems, I want to ask you about, there's a couple issues with technology, too, I want you to start to think about, because I think some of those articles do talk, and I do think you have. The small practitioner has a better chance these days through the use of technology with litigating these claims against much larger law firms successfully. And certainly in the course of discovery and obtaining information, the technology really levels the field in significant ways. I said I was in New Hampshire last weekend, and Friday I had to fax some papers down, and I really wish I had a scanner with me, and I hadn't. But I was talking to my wife, and she said, "Well, everyone's using now. They just bring the wand into court when they want the court file." Is that what that is? Can I see it? It is a portable scanner that works on batteries. I went down to FedEx, Staples. I sent 13 pages down from North Conway, New Hampshire. $26 by fax. This is a portable scanner. It's called the Magic Wand. It's $100. And it works on batteries, right? A couple AA batteries. And it scans a page in at a time, and when people want copies in court now, they're using the wand, and for relatively short money, they can scan in whatever they want. How long did it take you to get accustomed to the speed with which you could do it? Was it?
Just right away.
Oh yeah, really? It wasn't hard?
Yeah.
Okay,
And it
that's
scans as a
what-
JPEG, actually.
Right, as a JPEG.
Can you put it in your flash drive, or?
Yeah, you have a little.
It's got its own
SD
card, like a camera,
SD
right?
card.
Yeah, SD card.
Yep. And
Awesome.
yeah, it's amazing. And so in court, if people want copies now, that's what they're using. And the fact is that I would have been 25% of it already paid for by just having the scanner and then emailing it down instead of having to fax it. The point is that there are technological resources that you guys have got to be aware of. back when I started practicing, and even for a while, not just started, more recently, we're worried about, well, hey, listen, I can show you upstairs. There are boxes and boxes and boxes and boxes of paper from cases, and then you got to figure out how to assemble it all and make sense of it all. There were cases where we looked at 25, 30 cents per page for a copy. With that little wand, or a high-speed scanner, even better, I've got it all and can put it in an electronic database that's sortable and everything else. You guys have to recognize the technology has changed the way you can compete against other practitioners in the field, and it's important to stay abreast of it and figure out how that really does level the playing field, because I think it does in a significant way. And to the extent that you can acquire more knowledge about technology while you're here, you should.
I have a question
Go
for
ahead.
you. You said that's a great resource that you would take calls from MSL graduates.
Sure.
Do you charge for that?
No. A call if you got a problem. I mean, hopefully I may not get back to you as soon as possible, but yeah. But yes, but let me draw a distinction. I don't know what to do about X. Well, I've fully researched X, and this is what my choices are, and I'm confused as to which way I should go. That's a different question than what do you think I should do about a problem that you should have been able to or at least done some work yourself. And that's an important distinction. It's one thing, I don't know what to do. The clerk says this. Well, first of all, what does your rule book say you're supposed to do? It's one thing to have a dilemma and need some help with. It's another thing to be lazy and expect that your professor's going to answer every question that pops into your head. And that's the distinction. First, part of learning to practice law is you got to try, and you got to figure out what the rules do permit and what they don't, and pursue it. But yeah, when there's real problems, and I'm not the only one, that we all get calls. I got a complicated problem. This is what it is, Professor. What do you think? And a lot of times it really is. And if I don't know the answer, I say, I don't know. This is where I'd look. I can direct you places. But there are some times where the answer is just clear. What they're doing is they're trying to take advantage. Or sometimes you're just wrong. No, you can't do that. Why would you even think you could do that? And listen, even as a practicing lawyer, you oftentimes want a reality check. There's a lot of times when I've got a case, I'll go next door to Peter and I'll say, Pete, what do you think about this? I mean, I'm pretty sure we think a lot about things in a very similar fashion. But if he says, I don't know, Mike, then I know I've got to recheck what I'm thinking. And he does the same. And I think that's always important for any lawyer, is that sometimes to get what I call a reality check. I mean, you think this is right or you think this is wrong? Is my thinking messed up? And I think it's important, especially when you go back out, sometimes you say, you're confused or concerned you might be doing the wrong thing, and sometimes you are. And it's nice to hear, well, the other lawyer's not just blowing smoke. He's right or she's right, that you're way out there. I get calls from a lawyer far more senior than me that I used to work with, and she has issues that oftentimes she's still out there. She's got to get back on track. I think it's healthy for a lawyer to make sure that when in doubt, doesn't hurt to get a second voice. And so you should. And if they don't call, if it's a wills and trusts and they don't call you back, they don't call you back. But at least you tried, and you shouldn't feel like you can't try. I probably worked with graduates, and we've both made money. Probably at least half a dozen to 10 cases, and good money. I mean, not little thing. I have the ability to be selective, so I'm not, you got that malpractice on your dog, you're on your own. Sorry, Professor Sullivan. But actually, I probably is on your own, but it's a funny story, but it wasn't. They called a friend of my son's friend, and they said, you better get to it was like Petco or something. You better get here quick. They were shaving the dog, and they cut his artery. This is what they told him. And there's blood everywhere. That's what the message was. There's blood everywhere. I swear to God, this is true. There's blood everywhere. You got to get here right away and get him to the vet. Okay, first of all, if you did that, why don't you get him to a vet? Okay, she gets in the car. She gets in the car. She is so upset. You know, like a lot of us would be about our dogs. But think about someone like Diane or something, okay? Very upset about her dogs. She's so upset. She gets into a car accident on the way to Petco. And really, seriously, injures herself. Not permanently, but seriously injured. But the car's totaled. Okay? She gets there. There is blood everywhere. They get the dog to the vet. They save the dog somehow. But this is like a law school exam, okay? Now, I don't know what that case is. I don't even know. Right? The dog isn't worth much. The dog's better, but we got a surgery, we got all this. But I'm just using it as it's an illustration that, you know, a lot of times you need to work through your cases. But there are times when you want some help. You know, I had a great invention dispute with one of the graduates. I mean, great case. Great case. Great
I
case.
just asked because
Yep.
it's nice to know.
Oh, sure.
Not that we're going to call you, but it's nice to know.
Call on those big ones especially.
You know, it's nice to know that you don't just graduate and you're out there all alone. It's nice to know that you have that support staff.
People, I know because Peter's office is next door to me. He does the same. The people call Peter all the time too. You know, and they call me about Lynn Lieutenant. I tell them call Peter because I don't know anything about it.
And I saw his name in the newspaper recently too.
Yeah. No, he's a very good lawyer. Let me ask you. One of the articles you should have read was an older article of mine. Are there principles by which you will practice law that go beyond the law? Sunshine's nodding her head vigorously. Yes.
I loved your article.
Oh, thank you.
And I wish there was more like that. And I actually stopped everything at work today, and I was like, I'm just going to read it, nobody bothered me. And I loved it. I love the fact that you're not just saying, let's just do law and be like this, because the people that do come to us are going to have issues in all realms of what they face in life. And I think that that's a more wholesome way of practicing law than just, this is what the law says and this is what we should do. So I loved it.
But how would that affect your practicing though? I mean, are you going to tell them? So you represent the father that's not supporting his kids. Are you going to say, look, buddy, you know, I'll represent you, but this is a bad thing to do. And the fact is you're going to regret this in 30 years if you don't. You are. So you're going to give them personal advice to live by.
It would be on case-by-case basis for me.
Yeah, I don't disagree. There's some, you know, listen, I don't care enough about you to bother.
Right.
Right? Maybe I won't help you, but on some of them,
Yes.
so guess what?
You should.
Yes.
I think that you will need to be able to articulate that to some of your clients because it could be a deeper issue. It's more than, I'm just upset with my children's mother. No, why? Why are you upset? Well, I don't think that I'm the father of the children. So let's go get a DNA test. Because things like this happen. I have a guy that I work with, and it is in the air whether or not the child is actually his. And he refuses to get a DNA test. And we're like, the manager has even said,
You realize
I
he's
will pay.
refusing to get it because he knows he's
Yeah.
the father, right?
Well, he could be, but he was like, well, he's been excuses. Well, I don't have the money, so even the manager.
Well, these
has
days, a
said-
DNA test is not that
I
expensive.
agree.
You know what a month's worth of child support is?
I agree. I mean, but he does take care of his son. He's constantly with his son
Yep.
all the time. But it's questionable as to whether or not it was a wholesome woman that he slept with unprotected. So that is the issue there. But, you know, he's like, I want this to be my son. He wants responsibility, so I commend him for that. But still, at the end of the day, in the back of your mind, that might be something that I want to know. You know, so, yeah, I think that you should, as an attorney, be able to pull your clients to the side and be like, listen, we're representing each other. We're going to have a relationship that we have here. So, yeah, we need to talk about some things because there are certain responsibilities that you need to have as a man.
So you're going to give them moral advice as well as legal advice?
I give them
They get it
hints.
from me.
Huh? You give them what?
Hints.
Hints?
Oh, I come out
No, I
straight.
come out straight
Straight shooter, baby.
I gotta ask you though.
I would say the advantage of paying child support and, you know, point that out, you know, paying child support could minimize your whatever, you know, your situation could get better and
They're going to say,
You know,
well, I don't want her to get this
alert
money.
them into making the right decision. But I won't be like.
But sometimes people,
This way, 'cause
you're
they have to
not
choose.
going to be able to hint them into the right position, right? Some of these people are going to need
Fine.
forceful direction.
Yeah.
Look, you screw up again.
Yeah.
No, really, right? You screw up again, you're likely to be going to jail, and you're too young to be doing this.
Yep.
Yes.
I'll be here to represent you. I like making money, but you're messing up your own life.
Yep.
And if you choose to continue down this path, you will pay the price. I mean, is that.
Did you
or-
read the article about me and the reformer?
Yes, I did.
There was an attorney that, and I'm going to say this, I'm kind of like embarrassing crap, but there's an attorney that changed me from doing some really bad things in my divorce and being who I was as a person. So yeah, I think, again, because he did that for me, I don't see why.
So you owe more than just legal advice.
Yeah.
Because this is what I do think strongly. 'Cause lawyers are community leaders, right? Lawyers are respected people.
Social
And you do have the ability, not just as a lawyer, to effectuate change in a courtroom and elsewhere. People look up to you. So with that in mind, then don't you have a greater responsibility to try and do better?
Yes.
I agree, yes.
So you're prepared to do, and are there times where, then does that also mean though that, like, I'm not going to represent the child molester? I'm not going to represent the batterer.
I would never,
Never.
ever,
Period.
period.
Are there other types of cases that you would never do?
Probably rape,
Rape. Well, alleged rape.
alleged.
But even an alleged rape, Patrick's on his own.
No, I mean, I would represent, I would do that, and.
You would do what?
I would
So you are going to
represent
represent the alleged rapist?
Yeah, I would. Child molester, I have an issue, alleged child molester, but rapist, we can talk about some things.
That's an interesting line, no?
Well, kids are vulnerable. They're kids. They're innocent.
And the victim of a rape wasn't
Rape?
vulnerable?
No, wait, no.
But what about that?
No,
What
that's
about-
not what I meant.
what
I'm
about
saying,
that-
Wait a minute, let her finish.
I get her point. You're talking about adult versus a child. You know, the child can be scarred for life, you know, and an adult, yes, but still there's, I don't know, kids more sensitive, I would say.
I do understand your being protective of the child.
Also, I'm a mom, so I feel more for it.
Well, go ahead, you want?
Yeah, so alleged is the key, because what about that child, wasn't there a big child care place where they convicted all these child care? and they were-
Fellsacre in,
Yeah.
but there was there was some evidence to support it. But wait a minute though, because they're all alleged until they've been convicted. And this is the question: is that okay? They're alleged. I'm looking at the evidence. Like when I used to do when I was in Boston, I did DUIs. Listen, if they're arrested after a Bruins game between 2 and 3 a.m. in the morning, they're pretty much likely to have done exactly what it is they're alleged to have done. My wife had one time. He was seen in the Somerville prisoner's dock before they did the breathalyzer, and he is drinking out of the toilet in an effort to, again, late at night, trying to ingest enough water so that he would somehow thinking he was going to dilute his breath sample. And they've got it captured on the tape. It's probably not a case you're likely to try. No, but some of them, you're alleged, but we look at the evidence and we say, oh my God. I mean, aren't there?
But
Go
if
ahead.
someone comes in the office and if he confesses to you that, you know, he molested or he raped, I would say no. But if someone comes in the office and tells me, no, I didn't do it, or it wasn't like that, or whatever, maybe. But
So you
not a
represent the
child molester.
rapist and the liar, but not the honest rapist.
No, neither.
No, but right, so the person that comes in legitimately feels remorse for what they did and say, I did this, but I need you to represent me. No. But the one that comes in says, pathological and says, no, don't even know that woman, right?
Because if the one that confesses I would be biased. I do have kids. If you confess to me and you say that you molest children, as much as I'd like to be vigorous about representing you, I won't do you justice.
So I need to lie to my own lawyer to get her to represent me.
I'm
If
not
you
telling
reasonably
you that. If
believe-
you choose to do that, you go right ahead. I'm not saying that you have to, but if you do confess to me, I'm gonna say, I'm sorry, I'm biased already.
I'm with you. I think if a person confesses to me, my question is, are you gonna admit guilt?
No, I want you to defend me.
Then I can't do it. I think my moral compass,
Yeah.
my moral compass comes into play, and I
So, but just to play the devil's advocate, you're encouraging your clients to lie to you.
And you're not gonna let them get on the stand and lie anyways.
Well, but we know the rules do permit them to tell a story, so it becomes more problematic as well. I'm not saying you're not right. I'm saying that then.
They can get Gary and Gary will represent them.
Right.
Well,
Yeah.
listen, I've always felt that way. There are cases I don't have to take, but they can find some other lawyer, right? Most of my work now is virtually almost always plaintiff's work. That's what I do, plaintiff civil cases, because I don't even like defendants that much. But right? And I get to pick and choose, so that's what I do. And so we can pick and choose, but I'm picking more just for money. Right? You're picking for moral reasons as well. And I did as well. I mean, I don't disagree that you shouldn't be able to do that. Are there other types of cases where your moral views will override your legal opinion on cases? I mean...
Seeing sunshine threw me under the bus. I have to defend myself a little bit, but no,
You know you would represent Gary.
I don't know that, but I will tell you this. I will admit this much, that 2 years ago, before I started this process, I would have said no. And I think maybe blame it on age, I don't know. But I just think that more so lately, I think that professional detachment needs to take place as well at some level, where you have to say, okay, I'm going to give this person a competent professional defense because I'm working for the public defender's office or whatever, and I got stuck with this case. The judge gave it to me. I don't want it. This is ugly stuff. I don't even want to read the evidence. I don't want to get involved with any of this stuff. All my charities are children's charities. The last thing in the world I want to read about is a child rape. But the bottom line is a professional detachment. Now, and I'm going to be honest, and I'm saying it on tape, I'm not going to give this person 150%. It's not going to happen. I'm going to give him a professional, competent defense so I don't get sued, and that's all he's getting. I mean, he's getting 60% effort. I don't know what it is, but somebody has to do the job.
Don't they have to get your full efforts if these guys have decided that, wait a minute though, these guys have decided, there's some cases I'm not taking, but I assume, there are some cases I'm not taking, but the ones I do, they get everything I've got. If they get you, or Cal, or Patrick, or Derek, or whoever, do you, I was going to put words in your mouth, but I won't. They're entitled to 100%, aren't they?
They are entitled, and so for you to say that you're not going to give them whatever you got.
I should have used the term 60%. They're going to get a professional, competent defense. I'm going to do my job.
And
that's it.
And that's great that you could remove yourself. I, on the other hand, cannot do that, and so I'll be the bigger person and say I can't do something at the front than to say I'll walk you through this and screw you in the back.
That's a great argument.
And I'll tell you this, Professor Cohen, one of the things that I noticed you did is immediately when Kelly said about the guy that he needs a DNA test to see if that's his son or not, the first thing you said is, oh, and you immediately knew. And there's attorneys, and I think it's your experience, there's attorneys that can sit with a client and automatically see right through them. And I am so gullible and naive. I believe them until they confess and say, I molested this child and then I hate you.
I had a
So
guy
how do you get
that
to
had a long-term relationship with a woman. He had 5 kids with the woman. Comes in to see me after the relationship's over, and he says, I don't think any of the kids are mine, okay? And then I said, well, that's simple enough then. We can just go get a DNA testing. And even, DNA testing back then, it still wouldn't have been as much money. But I think we were talking $1,000 for the whole bag, for the whole group. He says, oh, that's a lot of money. I said, do you have any idea what 5 kids in child support will cost you otherwise? At the end of the day, he said, I don't think we need it. I felt like saying, yeah, I don't think we need it either. I mean, at least 3 of them are probably likely to show up. And so, right, listen, child support, the DNA test pales in comparison to what the ramifications of long-term child support are. Take a look at this DePinet case. I want to talk a little bit about it next time as well. First, technology safety systems, because I think it's an important case. There aren't too many cases where you see the pre-judgment, really case where the court authorizes the seizure of evidence so that it can be held, and especially as you start to think about electronic evidence, even though there are discovery rules designed to prevent and require you to preserve electronic data that either once litigation is filed or when you're aware that litigation is likely, we still know that with the push of a button or a whole bunch of different things, it's relatively easy to get rid of evidence. So I want to just touch base on this because the way in which the evidence then was preserved was grossly improper. But it does have you start to think a little bit about those cases, especially where I think it's likely that, and I have some support to show it's likely, that the defendant is going to destroy evidence that might be essential to my case, to maybe think about going in for a TRO without notice to the other side in order to grab that evidence before it can be lost. It's going to take an extraordinary showing to get it, but certainly if we can, frankly, the case will be over, as you saw from the crash dummy case. So we can just touch briefly on that the next time. Hopefully you'll all be safe in the storm.
Thank you.
Oh, thank you. Yep.
Traffic point, you go up to North Conway.
Yep.
So, I had reservations at the Wine Mountains Resort.
Oh, yeah?
Saturday and Sunday.
This Saturday and Sunday?
What would you recommend?
You can get there. I mean, my daughter went up.
But I would leave Saturday around like 11 morning.
But I thought you said Saturday and Sunday.
Yeah.
I think you might be okay by then.
Okay.
It's beautiful up there.
I know, right? Yeah.
Oh, yeah. Wait, Cathedral Lake? I think that's the one that has a pool. You start inside, go outside.
I think I never been there.
If it's the one, I think you can go there a lot. It's a beautiful hotel.
Yeah, it's a beautiful place, yeah.
Call them, see if they'll postpone it a week.
Right. But I don't know if they're on, they've only come like to Storyland, so.
It's off West Side Road. You know where West Side Road is? I would still take Route 16. I'd take 495 all the way over to the Spalding Turnpike, Route 16. 93 takes a lot longer to get there. It's beautiful, and they're going to get a foot of snow up there. Oh, yeah. How old are your kids? Nice. Oh, you'll have fun. You call, they're very nice. They might postpone it a week while you're worried about the trip.
They said they would, but I really wanted to go this weekend.
I hear you. I can tell you this. New Hampshire takes care of their snow very well. Really. Uh-oh. They take care of their snow very well. No problem with getting from Hudson to, say, Rochester, New Hampshire. That would be tough. But if you by noontime, that restaurant there is very good. That's a pretty hotel. They've got a pool that you shot indoors, you can swim out, you can look at Cranmore at night, when you might have Cranmore. Very pretty. Yeah.
Am I understanding this right? Do I have 16 credits for law yet or no?
Yep. You can only count 2 required, I think, right? You've got 3 in there.
3 in there?
Right, you've got con law too. So.
Yep. So I can
Is that what it says? It says only
my
2?
law and psychiatry is
Yeah.
not a required, so I can keep
Yeah.
that one.
Oh, yeah.
But then I would have to choose.
Oh, I see. No, you got this.
So I get 7 credits then? If I
Yeah,
get
3 or 4 is 7. Yeah, you got 3, 7, 10, 13.
Are you 13?
That's what it says.
Oh, is family law not required? Or is
No,
it
family law is not required. You're wrong. No.
That's good. Yeah, that's close.
Okay. Okay.
sunlight.
Oh, really?
So strange, like, you know, it's just like a weather alert.
Open on Saturday, work on their state.
He's been. Did you put it on yet? Did you put it on yet? I was like, you're worried about the wrong person. Did you turn it on? Yeah, it's still running.
Yeah.